So the next aspect I thought we'd look at is the issue around context. Um, for a few years now, the NMC have been requesting that registrants fill out a context form. And this is really good because it means that they're appreciating that there's often lots of other things that happen around a referral. And it's important that they get information about context. So it might be that staffing levels or other issues going on, maybe the unit was failing in some way, or even context around the registrant's own health. And, it's really encouraging that the NMC are asking for this information. But what we're finding is, although they're asking for it, they're not putting particularly that much weight onto it. It's almost like they've asked the information and then it's put in the file and not really looked at again. Now, I might be wrong in that, but that's just my impression. And again, with this case, Judge Alan Bates recognised this and made a few observations about how context should have been examined in more detail by the panel. So he said that the misconduct, if there was any misconduct, it consisted around administrative tasks and things that administratively the registrant didn't manage to do. He said that these failures occurred while she was working in a very toxic workplace environment, and so therefore she was likely to have been put under a great deal of emotional strain, and that might have affected her ability to focus on, say, the admin versus other things. He said that there was no evidence that her relevant failures that actually caused any harm to patients in any way. And that should have been taken into consideration and at least discussed in the panel summing up. He also said that this registrant complied all the way through. She attended the 34 days of hearing. She provided evidence to show her remediation on the aspects that she did agree to. And she tried to engage as much as she could. She was there at the hearing and gave evidence as well and answered questions. He said that there was no evidence to cover up, no evidence of her trying to avoid any responsibility for any failures. And, she was willing to be completely open and honest, as she should be. The last point that he said was that there had been, as I said before, a substantial amount of years where she'd been working since the concerns were raised, and that there'd been no repeated issues again. So again, once more saying, what are we looking at here? Are we looking at a nurse that's gone from employer to employer and had mistakes all the way? Or are we looking at a nurse that's had one area of her working history? She's had problems for whatever reason that is. She's now moved and she's worked elsewhere for a substantial number of years. Laura had worked in the Children's Hospice for 4.5 years, and there's not been any other repeat or any other concerns raised. So again, it's important that the NMC really look at that properly. Again, the judge said that the panel failed to explain, in respect of the disputed allegations that it found proved, why it had preferred the account given by one or more of the complainant nurses to the contrary account that was given by the appellant, so Laura herself, and also where it was relevant to, there was a paramedic that had witnessed during some training, I think, he'd witnessed some of the behaviour of these nurses, and he came and gave evidence to show the panel what Laura had had to contend with when she was managing these people, and to attest to the poor behaviour that they had had. And the Judge Bates felt that this wasn't looked at properly by the panel, wasn't considered properly, and even if they did in private consider it, they certainly didn't explain their reasoning in their judgment. Judge Bates went on to say that the applicant, so Laura herself, was entitled to know why her evidence on the relevant matter had not been relied upon by the panel, and as such, what reasons were given in that regard had to be rational and based on weighing up all the legally relevant considerations. And he just felt that the panel didn't give enough explanation in this aspect, that they made their decision. They said that they'd made their decision, but they didn't actually explain why they'd made that decision and how they'd come about it. And that's, one of the things about cases is that registrants just don't understand how the panels have come to the decisions they've had. And whilst there's no, I suppose, is there any legal obligation that they do explain that? Morally, I think when you've got a registrant that potentially is having her career ended, they're entitled, or they should be entitled, to the respect of being told, exactly how that decision making's been made, because otherwise, how can they improve? How can they learn, and how can they make things better when they come back to work? One interesting point was that there was an investigation conducted by Laura's old employer, and it was conducted by somebody who was completely independent and impartial. This evidence wasn't put forward to the panel, and the judge criticised this. He said it would have been very helpful for the panel to have seen this so that they could have all evidence in front of themselves when making their decisions. Again, this is an aspect that our members tell us time and time again. They say, oh, the NMC won't let me put that report in front of the panel. They won't let me put this piece of evidence, I don't know, a rota or a prescription or something, that the NMC are refusing to let me put that in front of the panel. Well, it's the evidence, and the panel should have all of the evidence in front of them so that they can make a proper informed decision. There's been a few appeal hearings where the judges have criticised this aspect. Over the last, I think since 2009, there's been 45 appeals that have won through the High Court and overturned the decision making of the NMC, or remitted the case back to another hearing. And some of those judges have picked up on this point, that they've said that, panels have to have all of the information so that they can make the judgment. It shouldn't be a game plan by the NMC lawyers to decide what evidence goes in front of the panel in order to help them win their case. It's just simply not good enough.